An addict with a new baby faces prison for a string of felonies. The state says she's blown every chance. But today, her attorney says she's finally clean, accepted into drug court. Judge Boyd offers her a choice that could save her or send her away for decades.
2025 CR 000240 and 2025 CR 013090. State versus Elizabeth Settle. Can I have parties announced for the record?
Hunter Morris for the state.
Will Brooks for the defendant, Judge.
All right, and you're Miss Settle? All right, we were here on July 28th. The court ordered you to have a drug testing done, and that was completed. Is that correct?
Yes, Your Honor.
And what were the results?
So she was positive, Your Honor, but it was for her medication assisted treatment. There was nothing else, no other substances.
All right, so the other reason why I had this case recalled back, because this is actually a tough case, right? And it's a tough case, and when you read it on the surface, you should be going to prison. But then there are other things for me to consider as well. The fact that you have a child, and it appears that you have changed your life. And defense, I believe yesterday you said that she was being accepted into felony drug court.
Yes, Judge, and also I had some argument for the court too. The court was ready, but that is correct, Judge. She was screened for felony drug court. They did not accept her because at the time she had not been sentenced. But I verified with felony drug court that should she be placed on probation, they're able to accept her in and can squeeze her in next week.
All right, so state.
Yes, Judge.
I understand why the reason you're asking for prison time. I do, and I want you, Ms. Settle, to internalize what I'm saying. What I'm considering is the fact that she has a child. It appears that she has changed. Sometimes it takes people a long time to have a wake-up call. I still don't understand why you keep having children when your life is not where it should be. But usually when people are addicted to drugs, they're not thinking appropriately to begin with. They're not thinking about the future. They're not thinking about how their drug use will impact everyone else. And state on this case, I see that you're asking for a cap of 6 years in the prison. And one case is a second-degree felony. And the other case is a third-degree felony. And I'm assuming she has restitution to pay?
If it isn't included in that plea bargain right there, Judge, then no certain amount.
All right. So we're going to see the amount of restitution, and state you've had a chance to hear her testimony. Are you still going to be requesting prison time?
Judge, the position of the state is that this offer was made considering the history, the knowledge that Ms. Settle has been before this court previously, also with a new child, asking for the same type of leniency and treatment, and was offered that leniency and treatment and turned it down and returned directly to that life. And so it's not just Ms. Settle the state is concerned about, but it's Ms. Settle's children, it's Ms. Settle's family, and it's Ms. Settle's community, many of which were victims of Ms. Settle. And that is the reason the state is opposed, but the state is cognizant of what appears to be genuine changes in Ms. Settle's life.
All right. And I know that this involves her mother.
Yes, Judge. So the world is an ironic place. It turns out I'm appointed to represent Miss Settle, but I have known Miss Settle since she was about knee high. I've known the complainant, her mother, and also her brother, who's referenced in the PSI, someone that I went to high school with, was close friends with. So I've known this family a long time. I've spoken to the complainant, to her mother, Judge. She is certainly at wit's end with Miss Settle. She's spent a great deal of money helping her out, trying to get her on her feet. But it is also clear in the PSI that she is seeing and she's witnessed some of the changes that Miss Settle has made in her life. and is made. And the question came up yesterday, Judge, what's different or what's changed? And I think the distinction between this time and last time, she did not do what she was supposed to do for you, Judge. It's very clear in the PSI, back in 2020, they were going for things. She was released from the jail accidentally, she skipped out on GPS. There were all sorts of issues, Judge. In this instance, since both when she was arrested and then certainly after being released on bond, she's made great strides to try and do what she's supposed to do. She's been on GPS, she's been compliant, she's been enrolling programs, she's tried to be a parent to her mother or to her child. She's also shown up here today, Judge. She's not run off, she's not fled, she's not skipping out on things. And when you're talking about therapeutic justice, Judge, when someone's an addict, there's no such thing as a cure. But it seems to me like she's trying to make some legitimate life changes. And I think society and Miss Settle would be served better by trying to get her some therapeutic justice and trying to continue her down this path rather than sending her to prison again. PSI, the complainants themselves don't indicate that they'd like Miss Settle to go to jail, prison. Her mother certainly would like Miss Settle to have the threat of prison or jail time hanging over her head, which is something I think is a great motivator a lot of times. So for those reasons, Judge, we're asking the court to consider probation or community supervision in some form in order into the drug court program.
All right, anything you wish to add, State?
Judge, the state stands by its concern about Ms. Settle being a good probationer, a good candidate for probation. That being said, the emphasis from the complainants was that if this court were to grant supervision, the state would ask for a very structured supervision, because I do believe that it is a necessity in Ms. Settle's life at this point. I believe drug court would be appropriate and, if needed, inpatient treatment.
All right. So the court is going to give you a choice. Some people say my probation is very difficult. I'm sure you're aware of that, as I've sentenced you before for not doing what you're supposed to do. I'm going to give you a choice. I can sentence you today, and I will sentence you to 3 years in the prison. Otherwise, the plea negotiation needs to be reworked. And by that, this is what I mean. The case that's a second-degree felony, I will give you deferred adjudication. And if you were revoked, you're looking at 20 years in the prison. Do you understand? Sure. And then on the case that's a third-degree felony, I would convict you, but I want the underlying to be 10 years. So you can discuss that with your attorney.
Judge, you'd like the opportunity for probation, Your Honor?
All right, so normally, legally and ethically, I'm not allowed to interfere with negotiations. But what I'm telling you and telling your client, on the cap of 6 offer, for me to request that it be an underlying of a cap of 10, that's changing your plea negotiations. And if you want a jury trial on that, you can have a jury trial on that. Do you understand?
Yes, ma'am.
All right.
Judge, on the second-degree case,
Mhm.
is there no application for deferred indicated in that plea bargain agreement?
On that one, let me see. No, it just says that you're all opposed to community supervision in deferred adjudication, but I do have an application for deferred adjudication on that case. And on the firearm case, there is again, there's, the state is opposed, but there is an application for deferred on that case.
So the only one we would need to change is the one with the conviction, so the third degree.
Yes.
This court could give them 10 years deferred on a cap of 6. Opposed.
Well, no, on the unlawful, we're off the record, on the unlawful possession, the court wants a conviction on that case.
Okay.
So there will be guilty but I want her underlying to be the 10 years.
Understood.
And then on the other case at the second degree, I'll give her the deferred adjudication. So the reason why I'm doing that is because then on both cases, you would be subject to the full range of punishment if you were revoked. Do you understand?
Yes.
Understood, Judge.
So if you all want to change that to a cap of 10 and state, I'll still note that you're opposed.
Yes, ma'am.
And Ms. Abrams, on Ms. Settle's, defense counsel has told me that felony drug court will accept her. And counsel, is she currently on GPS?
Yes, she is, Judge.
All right, we're going to continue with the GPS. Yes.
The case ending in 240, are we proceeding on count one or just two?
Let me see. They're proceeding.
Okay.
They're proceeding on count 2 as a repeater. I'm sorry, wait a minute. They're proceeding on count 1. They're waiving count 2 in the repeater.
Judge,
Yes.
here's that docket back and we initialed the plea bargain change.
All right, thank you, Hunter. All right, we're back on the record. Is there anything else from either side before the court enters its orders?
Nothing from the state, Judge.
No, just that we have no objection to the change from the cap 6 to the cap 10 here.
All right. Then in cause number 2025 CR 000240, the court is going to grant your application for deferred adjudication. Court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. This is to run concurrent with 2024 CR 013090. With regards to this, no harmful or injurious contact with KPEC and family. And then there's no contact with Linda Vargas, Destiny Thurston, Juan Uriega.
Uriega, Judge.
Yeah, thank you. I look at Deputy Laura because she's like, I'm trying to teach you. David Getz, Goetz, or Dick Creamer. And there'll be restitution, if any, to all complainants. If there's an issue with the restitution amount, we can have a restitution hearing. And Ms. Ferguson, can you set this in 45 days for restitution hearing, please? In case there is any.
Fair enough.
All right, what date? All right, we're going to come back on September 11th and state this just to see if there's any restitution amount that's owed. And we'll have a restitution hearing on that day.
Yes, ma'am.
Just one moment. Deputy Laura, are you okay? Thank you. All right, there's to be no contact with Rudy Rodriguez. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 100 hours will be deemed satisfied. There's $1,000 fine that will be probated. And there's to be a referral to felony drug court. If for some reason she's not accepted in a felony drug court, she's to come back to this court. However, counsel has informed me she has been accepted. And there's to be continued GPS until further notice. Probation, is there anything else with regards to that sentencing?
Yes. Are you waiting?
Yes.
And can you please? No contact, did you say no harmful or injurious?
No harmful or injurious contact with Peck, P-E-C-K, and family. And then there's to be no contact with Linda Vargas, Destiny Thurston, Thursten, Juan Uriega, David Getz, Goetz, and Dick Creamer, and Rudy Rodriguez.
Judge, to put a fly in the ointment, Mr. Rodriguez is actually the child's father.
I'm just going by what's in the plea paperwork. So that's something that will need to be addressed with Judge Glenn. Probation, is there anything else? Anything else with regards to sentencing in that cause number, counsel?
Nothing from the state judge.
Nothing from defense, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. In that cause number, did you review it with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Next, we're moving to cause number 2024 CR 01309. All right, the court is going to sentence you, the court is going to find you guilty. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. 200 hours of community service restitution. The court will show that 100 hours is satisfied upon the completion of parenting classes. GPS, and I'm sorry, probation will do partial GPS for employment and treatment in each cause number. Waive GPS fees. This is run concurrent with 2025 CR 000240. And referral to felony drug court. And again, if felony drug court for some reason does not accept her, she's to come back to this court. Probation, is there anything else with regards to sentencing?
It's on the other call number as well, field visit.
Oh, thank you so much. Field visits one time per month until further notice.
And can you clarify which count on that call number?
The one I just read, the unlawful possession.
Yes, Judge.
They are proceeding on count 1 and they're waiving count 2. Is there anything else with regards to sentencing in that cause number?
No question.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You say you have a new child. Your counsel has told me you have a newborn, that you have finally, the haze has been cleared and you're finally going to do what needs to be done. In each of these cases, in one case, you're looking at 20 years if you're revoked. In the other case, you're looking at 10 years if you're revoked. So from here on out, everything you do, you need to ask yourself two questions. Is this something that could potentially result in me being revoked? If the answer is yes, don't do it. If the answer is maybe, don't do it. If there's anything else that's in between, you need to contact your attorney. Do you understand? All right. And if you're not going to do it for yourself, you need to do it for your child. All right. Thank you, counsel. Thank you.
Thank you,
Thank
Judge.
you. It's always great seeing both of you guys.
Me too, Judge.
All right. Thank you. 2022 CR 10260, State of Texas versus Maria Antoinette Neely. We're going to have parties announced for the record for the state.
Jason Garahan, Your Honor.
Defense.
Meredith Stone for Miss Neely, Your Honor.
And are you Miss Neely?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor, and I have signed the discovery acknowledgement. And before we begin the plea, I just need to put one short thing on the record with my client, if that's
All right. So the court will find that the state is in compliance with discovery and you may put on the record what you wish.
Ms. Neely, you had originally filed a motion to have a different attorney appointed back in November. Are you asking the court to disregard that and have me continue as your attorney today? And are you satisfied with my representation? Yes.
Oh, thank you. All right, Miss Neely, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
we do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Neely, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
And did you understand what you're charged with is manslaughter as a second-degree felony? The range of punishment is anywhere from 2 to 20 years in prison with a possible fine up to $10,000.
Yes, ma'am.
And the repeater, Your Honor, we're proceeding with that.
All right.
Okay.
And so with the repeater, if it's proven, then that makes it a first-degree felony. The range of punishment for that is anywhere from 5 to 99 years or life with a possible fine up to $10,000. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and rights to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Neely, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
Mhm.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, you agree that you've been previously convicted of a felony for purposes of enhancement. Punishment is be assessed at 8 years in the prison. There are no applications, and the state will take in consideration 2022 CR 10259. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, exhibit number 1 with all of its attachments, Your Honor.
And I've gone over that with my client. We have no objection, Your Honor.
Ms. Neely, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 in attachments. To the repeat offender enhancement allegation, how do you plead? True or not true?
Sure.
Reviewing states exhibits 1 in attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and also based upon states exhibits 1 in attachments. Are you proceeding with sentencing?
Yes, Your
Anything you wish to say on behalf of your client?
Honor. Your Honor, my client's taken responsibility. She also has a federal case that she has to take care of. And when she finishes her sentence on this case, she'll be going there. So we'd ask for credit for time served.
All right. And is the felony case, I'm sorry, is the federal case still pending?
No, she was on supervision, so it's going to be revoked, I believe.
All right. I mean, I could ask that this run concurrent with that.
If there's a
but,
way to make that happen, that would be excellent. We would ask for that.
I can tell you because I guess technically you haven't been revoked on the federal case, even though I say run concurrently, it's really up to them whether they will do it or not. Do you know what the case number is?
No, we don't.
All right. If the court is,
It's like different cases.
all right, the court is given the case number, the court, of course, will add that and have it added into the judgment. But for now, the court is just ordering that it run concurrent with the federal case. All right, is there anything else from either side with regards to sentencing?
State, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. What are you planning on doing with the rest of your life? That's something that you need to be thinking about, unless you want to be the person who, when somebody comes to some institution, says, how does this place work? And they say, oh, you need to speak to the oldest person here. And they say, who is that? They're like, oh, we call her Grandma Antoinette. Or either with you, they may say, we call her Queen Antoinette because of your middle name. And then you find out you're the oldest person at the prison. So you had better start making changes because it's not going to go well if you don't. You understand? All right. Good luck to you. 2024 CR 2468, State of Texas versus Lorinda Ann Tarango. Could I have parties announced for the record for the state?
David Martin.
Defense?
Marissa Giovanco.
And are you Ms. Tarango?
Yes.
Counsel, have you received all of the discovery?
We have, Judge.
Did you review it with your client?
We have, Judge.
Court will find that the state is in compliance with discovery. Ms. Tarango, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on an indictment as presented?
No, Judge, we're going to proceed on the lesser included offense of assault causing bodily injury, Class A misdemeanor.
No objections.
All right, is that going to be family violence?
No, it's not.
All right, Ms. Tarango, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor?
Yes.
Range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to a $4,000 fine, and up to 1 year in the Bexar County Jail? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do believe she
Do you
does.
believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Durango, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, state is proceeding on the lesser included offense of assault, bodily injury, and they're recommending deferred adjudication. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for 1 year. There be no contact with the complainant and anger management. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Offer states one with the attachment.
No objections, Judge. I have gone over it with my client.
All right. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, my client has no criminal history. She works for the U.S. Attorney's Office, is that correct? And she's been there for
10 years.
10 years. She is an upstanding citizen and she made a mistake with a
Not made a
teenager.
choice.
Absolutely. She made a choice and she understands that and is accepting responsibility for her choice. And we just ask that you follow the plea bargain, Judge.
All right, so what happened?
We were at a volleyball game and the child came, it all started off with the coach. And the coach's child was bullying one of the other kids. And I went down there to break it up. And anyway, the girl called me a bad word.
Mhm.
So my husband at that point got up, we got up to leave. And I was talking to one of the parents. And well, they got up and they left and they came through where I was standing speaking to the other parent. And I made a bad choice.
All right.
Because she did call me another name again.
I understand. So you just can't do that. You understand?
Yes, ma'am.
And I see the game was forfeited because a lot of parents just left.
Yes.
All right. And the complainant, she's not related to you at all? This is the coach's child?
No, this is just another girl that played on the team.
All right. Well, I don't know when people will address bullying. My mom would address it head on. All right.
Well, I got in trouble for it.
Yeah.
And just one more thing, the other concern is my client's daughter still does play volleyball. And so I believe there is the possibility and likelihood that they will be at the same volleyball game. She understands she's not to talk to this child. She understands she's not to, sit next to
She's
them or
just gonna
talk
have
to
to
them.
drop her daughter off and
Okay,
wait in the car.
okay.
Sometimes these are consequences for our actions. So she'll have to drop her daughter off. And if anybody's being bullied, report it. And if that doesn't do it, because I'm assuming these are organized sports
Yes.
and they have higher ups. If there's an issue with the coach who's allowing the girls to bully each other, then you need to go above his head, or as they say, go above his pay grade. And sometimes when you throw the words in, well, I guess I'll have to get an attorney. That's usually when people stand up and listen. So if you put it in writing, I'm not telling you what to do, but I would put it in writing and say, this is what I witnessed. There's bullying going on. The coach is not addressing these issues. I guess after you, my next step is to contact my attorney. Then usually people pay attention. And I would also suggest that you tell them that you want to see their handbook, because they should have a handbook. All the organized sports are supposed to have a handbook like the schools do, what their rules are. And that way, when you send whatever letter you're going to send, you can go to a specific rule. And if they don't have a handbook, then they should. All right. All right. Do y'all want to speak of length of probation?
Again, Judge, my client is an upstanding citizen who's been a government employee for 10 years and she's never been in trouble before. She is motivated, understands what she did was wrong. She is motivated to do anything that you ask of her. And we ask that you follow the recommendation from the state and to keep it at 1 year probation.
The 1 year's our record.
Oh, see, but defense, since you told me to keep it at 1, I was leaning towards 6 months.
We're okay with that as well, Judge.
Well, you're gonna make an argument.
I reiterate all of my previous arguments, Judge. She will be successful. And I think this was a one-time mistake and I think 6 months is sufficient.
Okay. That just turned on a dime. We should bring Mr. Cox in here. Mr. Cox, you want to join in the argument? State.
And I do
Absolutely.
have to tell you, the child I was defending was not my child. It was another child.
No, I appreciate when people step up. I think we all owe a duty. It really takes a village to raise children. My motto is always, if you see something, say something, not, act physically, unless you have to, because there's no one else around. All right. State, I know you're asking for 1 year. Do you have any objection? It is a misdemeanor. She doesn't have any priors. At least that's what's being presented to me. There are underlying circumstances with why this happened. Is there any objection to the court going below your recommendation for the community supervision?
In the courts.
All right, thank you. All right, and then of course, if you are unsuccessful or if they feel it needs to be extended, it can be extended up to 14 months. You understand? Oh, wait a minute. Okay. Well, actually more than 14 months. You can be extended for 2 years, okay? All right, this is what the court is going to do. The court is going to sentence you to 6 months deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no contact with the complainant. If there are still volleyball tournaments, which I'm being told there are, you're just going to have to drop your daughter off. You understand? And wait in the parking lot.
Okay.
And you can always do the audiobooks in the parking lot. There's always something to do.
And Judge, she does live in Brewster County. If we can transfer to Brewster County.
Where's Brewster?
Alpine.
Where's Alpine?
These were my questions, Judge.
Have you ever heard of Sullivan State University?
Where's Sora State University?
Big Bend.
Okay, Big Ben.
Yes.
All right, awesome. So Brewster, can you spell that? I don't want to mess up.
BREWSTER.
Oh, it's like the women of Brewster Place. Okay.
Who are the women of Brewster Place?
Oh my God, you should be embarrassed for saying that. Although Zach doesn't know either. So,
Thank you, Zach.
I got you.
there's going to be a transfer to Brewster County. I'm going to order anger management. Probation, is there anything else she needs? All right, is there anything else you need from the court to be successful on this probation?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. I am not going to be the judge that is supervising your probation. Of course, probation technically was supervised, but if there's an issue with your probation, you'll have to go to the judge that sent this case to me to accept your plea. You understand?
Yes, ma'am.
All right, good luck to you. Is calling 2025 CR 008222 State versus Brianna Marie Gonzalez.
Todd Lester for Ms. Gonzalez.
And are you Miss Gonzalez? We're here today for sentencing. You entered a plea of no contest to the offense of robbery. According to your plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. State is silent on your application. There's a restitution amount that is listed as $2,000. However, in the PSI report, it states that they have not been given proof of any restitution, but that's what you all have agreed to. Taking consideration 2025 CC 003927. Have both parties had a chance to review the PSI report and TAP evaluation?
I have not, Your Honor. But I believe we're silent, so I don't anticipate having much comment on it.
Any objections?
No objection to the PSI, Your Honor.
All right. Do you have any witnesses?
No witnesses, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. We have applied for deferred adjudication. This is Ms. Gonzalez's first offense as an adult. She's young. She's just applied for the ability to go back and obtain her high school diploma that's starting on the 18th. She's currently employed. She has a place to stay. This was a very large lapse of judgment, which she understands. She understands the consequences of her actions. And if the court is willing to grant her the deferred adjudication application we've put in, she understands that even one little toe over the line carries with it some very significant consequences. Judge, we'd ask that you please grant our application for deferred adjudication and allow Ms. Gonzalez to prove to this court that she can be a productive, non-offending member of society.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Brianna Gonzalez.
All right, you need to speak up, so.
Brianna Gonzalez.
All right, so why did you do this?
Your Honor, I made a mistake. I was hanging around with the wrong crowd and
No. Let me just tell you, don't do I was hanging around with the wrong crowd, because if that other person were before me, they would say they were hanging around with the wrong crowd. And I would say, who is that? And you know who that would be? You. So why did you do this?
I wasn't thinking right. I was being dumb and ignorant.
Well, this person is supposed to be your friend. Is that not true?
No, Your Honor.
That's what it says in the stipulation, that they knew you. And this person gave you and the other person who you were with, who was your friend, a ride. And then you said, well, you know what? I just want to talk to them with us two alone. And then that person got out of the car so you could speak to them. And then you immediately get out of the car, get in the driver's seat, take off and hit that person with the vehicle. That's what the stips are. So why would you do this to a person who's supposedly your friend?
Arguing at the time, Your Honor.
No, it doesn't say anything about you arguing with him in the steps. What it says was Victim works as a taxi driver, gave his friend, that's you. So since they say friend, I'm assuming that you all have a prior relationship and he considers you a friend. So he gave you a ride and your other friend a ride. So your friend with a taxi driver and you have your friend with you and he gives you both a ride. And I'm assuming he was doing this out of the kindness of his heart. Did he charge you guys any money?
No, Your Honor.
All right. So he gives you a ride and you go to apartment complex and you tell him, I want to speak to my friend in private. So the victim gets out of the vehicle and then you immediately jump into the driver's seat and drive away. The victim gets hit by the vehicle that you're driving. And it says the victim had pain on his left knee from the vehicle hitting him. The defendant, that's you, struck the apartment complex gate, tearing off the front bumper to the victim's vehicle. So again, why are you doing this?
Your Honor, I was drinking that day.
I don't understand how drinking makes you do this. Because how did you end up even getting a ride from him? Did you pick up the phone and call him?
No, Your Honor, we were all under the influence at the pool, at the apartment complex, and went to go pick up more alcohol, and that's when I took the car.
No. I mean, there has to be a point where he's giving you a ride.
No,
Where
Your
does that come in?
We left from the apartment complex, Your Honor. It was me, my friend, and Moji. We were there at the apartment complex, and we all took off from the apartment complex, and we all left. He didn't give us a ride. We were all just riding together.
Okay. And then what happens?
I took off in his car,
Why?
Your Honor, because I wanted to leave where we were at, and I wanted to get back home, and we were arguing that same night. We had got into an altercation with my other friend.
That's not what the steps say. The steps say that you told him that you wanted to speak to your friend in private.
No, Your Honor, we didn't speak in private. We were all right there with the windows down.
No, I'm just telling you what the stipulations say. So why do you think I should give you probation and not send you to prison?
Your Honor, I'd like to get my life together and change my ways. I was a troubled teenager for my grandparents. Grew up in the CPS system, and I always ran away. And I feel like me getting myself together would be better and change my ways so I can accomplish my goals and work and continue taking care of my grandparents.
All right. And do you have any children?
No, Your Honor.
Thank goodness. So you said you grew up in CPS?
Yes, Your Honor.
So where are your parents?
I don't talk to my mom or my biological dad, Your Honor.
So you're just living with your grandparents?
Yes, Your Honor.
And who all lives with the grandparents?
It's me and my grandparents.
All right. Anything else?
No, Your Honor.
All right. And if you're drug tested today, what would the results be?
Your Honor, I smoked last night.
All right. And did you smoke at your grandparents' house?
No, Your Honor.
Where did you smoke?
Yesterday I went out with friends.
See, you're still making the same choices. And if you're coming to me and you want probation, the least you can do is come clean and sober. And you're not even doing that. So you're still making the same choices that are not good choices. So when you're smoking marijuana, are you going to tell me you were with the wrong people
No, Your Honor.
or hanging out with the bad crowd?
No.
You're part of the bad crowd. And do you have employment?
Yes, Your Honor.
What do you do?
I work at a range.
What does that mean?
Uh,
What do you do?
I take score of like when they shoot the rifles, and I take care of my grandparents on the side also.
All right, so that taking care of the grandparents, you're not doing a good job. So that's not going to be there. So you say you work on a range. So what are they shooting?
They're shooting like little birds. You push the button and they shoot.
Oh, it's the fake birdie things. And so what is your job?
I sit down and I just I'm a referee pretty much.
Okay. And does that pay enough to support you?
Yes,
And is that a full-time job?
it's part-time.
All right. So you're going to have to get a full-time job. You understand? and your grandparents, they're letting you stay there, so their rules apply. And if you want me to give you probation in this case, you're going to be on GPS. Is there anything, State, you wish to say? I know you're silent. I don't know if there's something you wish to say with regards to facts.
Your Honor, I know that the defendant had her recitation of the facts and the court is reading the facts from the STIPs. We don't have any information that the STIPs are inaccurate, so that's what I'll rest on.
Okay. All right, thank you.
Yes, ma'am. I also have a dismissal. For you.
Oh, this is county court.
no,
You'll have to
okay.
take it there.
Misdemeanor.
Yes.
I forgot about that. Thank you.
No problem. All right, probation. What conditions do you believe can help her? We obviously have drug issues, bad decision making.
Outpatient, it is recommended along with some support needing the regular random UA. I would also include more recognition therapy.
All right.
I don't know that she has her high school diploma.
How far did you go in school?
8th grade, Your Honor.
She's
Why
she's starting her program on the 18th, Judge.
All right, why did you drop out of school?
Was in CPS. They were taking me from foster home to foster home.
Okay. Oh. Do you need any type of therapy?
Yes, Your Honor.
Hmm?
Yes, Your Honor.
All right. So if we can do some sort of trauma therapy, I've done a lot of CPS cases before in my career as a defense attorney, so I know that there are issues. And I know a lot of times children get moved from place to place, and that's a bad thing because you've already been separated from your family, and whether your family is good to you or not, you love them. And then you get moved to a new place, and then a new place, and then a new place. Do you have siblings?
Yes, Your Honor.
And were you all separated?
Yes.
And have you had any contact with them?
Just got back in contact with them, Your Honor.
All right. So I don't know how your siblings are doing, but do not bring drama and conflict into their life. You had a bad start in life, and the reason why you've had a bad start is because you've been in CPS care, right?
Yes.
So you're going to have to turn things around and break the cycle. Please do not go out here and start having children until you are able to support yourself and support children. You understand?
Yes, Your Honor.
And do not choose some random guy to be the father of your child. You understand?
Yes, Your Honor.
And is there any gang affiliation with you?
No, Your Honor.
Okay. All right, probation, this is what I'm going to do. 6 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors, field visits 1 time per month until further notice, intensive outpatient treatment with probation. I'm going to ask that with the UAs, test for levels, those levels had better start going down. You understand?
Yes, Your Honor.
The MRT, take in consideration 2025 CC 003927, a $2,000 fine that will be probated. There's to be restitution to and no contact with Mojib, MOJIB, Rahmani, RAHMANI, and the restitution amount is $2,000. Probation, I'm going to ask for 200 hours of community service restitution. 100 of those hours will be waived upon completion of GED or trade school certification. The remaining community service hours you'll need to do. You understand?
Yes, Your Honor.
Probation, do you think we need GPS? All right. Is there anything else we need probation?
No, I just want to know, are you making it sufficient for her to get the principal?
No, because sometimes I would tell you, sometimes I realize some people are not good test takers, right? So what I'm telling you, if you obtain your GED or if you get a trade school certification, I'll deduct 100 hours of your community service restitution. Do you understand?
Yes, Your Honor.
All right. And then probation, if possible, some type of trauma therapy for her, please, to address CPS issues. All right. Is there anything else you need from the court to be successful?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. Everybody, I can guarantee you, your attorney has probably had bad things happen to him. Nobody has had a great life where they've just gone through and their life has been perfect. But you can overcome it, but you're going to have to fight to overcome it. You understand?
Yes, Your Honor.
And at some point in time, the fact that you were in CPS care, the fact that your parents didn't do what they needed to do, at some point in time, your choices become your own. And what I can tell you in this court, since you're on probation, at this point, you can put it on a calendar. Any choices you make, those are going to be your own choices. It's not going to be my parent did this or my parent did that. You understand?
Yes, Your Honor.
In this court, to be successful on probation, communication is key. If you have an issue, let your probation officer know about it. If you feel they're not addressing it, you can come back to court, okay?
Yes, Your Honor.
And here's my advice to you. I have no problem with tattoos, right? But if you want people to look at you and want to read your book for employment, you're going to have to stop with the face tattoos and stop with the piercing of the face. And let me just tell you why. Because if you come in for a job, some people are not going to take the time to look beyond this, right? They're just going to say, I don't think that person will be good. And they're going to move on to the next person. And you don't want that. You want people to get to know you and then say, yeah, this person is going to be great. All right. All right. Good luck to you.
Thank you.
You're welcome.
A 21-year-old meth addict with a long theft record pleads guilty. He's ready to do his time. But Judge Boyd gives him a blunt forecast: keep using, and one day someone will be identifying your body. Then she offers an unexpected lifeline.
Calling 2025 CR 013358, State versus Pablo Valdez. Can I have parties announced?
Melissa Albert from State.
Dwight Chumley for the bench.
All right. Are there any applications in this case?
No, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Valdez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Valdez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with theft of property less than $2,500 with 2 or more previous convictions. As a state jail felony, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Valdez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 12 months in the state jail facility. There's a $1,500 fine. The state will take in consideration 2025 PF 38482. There's to be no contact with Target or Walmart. Did you understand that to be your plea?
Yes.
Defense?
Yes.
State?
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and cite it in both places?
Yes.
By citing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No.
Then to the offenses charged, how do you plead?
Guilty.
State any evidence.
State offers into evidence states exhibit 1 with attachments.
No objections.
All right, state, you may be excused.
Here.
Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in both places, in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering into this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, discussed this case and the other case with him, and he's remorseful about it. He knows he's pretty young. He's 21, but he's been battling addiction for a while now, and hopefully he'll get some help inside there for a while and come straight out to some sort of help. But other than that, he'd like to do time.
All right, so let me just tell you the way I see your life going. What is your drug of choice?
Meth and heroin.
All right, so what's going to end up happening? You're taking the easy way out. You want to do your time. I'll let you do your time. But you're going to go to prison, well, the state jail facility, and you're going to have all these good intentions. It's like, I found the Lord. I'm going to be on the straight and narrow. Then time when you hit freedom and breathe free air, one of your friends or somebody's going to come up to you, and you're going to end up using, and one or two things going to happen. Either you're going to get caught before you use, which is going to be a possession case, or either you're not going to get caught and you're going to continue to steal to support your habit, or either the last time you use will be the last time you use and somebody's going to be identifying your body. So if you don't get your life together, that's what your future will be. Do you understand?
Yes.
All right. The court is finding you guilty. The court is going to sentence you to 12 months in the state jail facility. Give you credit for any time served. I request the therapeutic community
Thank you, Judge.
take in consideration 2025 PF 38482. There's to be no contact with Target or Walmart. And there's to be no contact with Adam A. Longoria. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because